And we're off. Court is in session, and things are about to heat up. Buckle up, because this isn't just paperwork. This is a defendant's freedom on the line.
This for preliminary examination, I believe I have all of the discovery, and then I can address the community corrections issue.
Why don't we address the community corrections violation now?
Yes, Your Honor. There is a slight language barrier with my client. He does have a green card, but he's from the country of Eritrea, I believe it is. He tells me that he didn't receive any paperwork when he was released from custody, so he didn't know exactly what to do. When I got the notice of the violation from community corrections, I advised him to go over there. Said
Classic courtroom clash.
And if they didn't have
Defense says it's a
paperwork, they wouldn't have set the
misunderstanding.
bond violation.
Prosecution
He's not telling you
says
the
it's a
truth.
lie.
I did.
Who do you believe?
Well,
They can face this
I
is where
apologize, Your Honor, on
credibility
his
can
behalf.
make
He
or
tells
break
me
a
there
case.
shouldn't be any. He did go over there twice yesterday asking to be enrolled in the intake process. He said that they told him they didn't have any paperwork for him to do that. So he's happy to do that right now.
That's not true.
I don't think there'll be any problems.
It's not
But
true. There's
Okay.
paperwork over there. I can see the paperwork over there. And if they didn't have paperwork, they wouldn't have set the bond violation. He's not telling you the truth.
I did.
Well, I apologize, Your Honor, on his behalf. He tells me there shouldn't be any issues if the court wouldn't mind passing hit for him to do.
When
the
did he
intake.
say he went over there? Because I'll call right now.
Yesterday.
Yesterday afternoon.
They wouldn't have. It's not true.
I did.
I can tell because I've got the bond violation here from me.
Okay. This is his first experience on this level with the legal system. So I would ask.
Probable cause conference will be adjourned August 28th, 2025, 9 a.m. At this time, the defendant's bond is revoked. Defendant's remanded.
Podium as we speak. Carl, want to get up here, introduce yourself to his honor.
Carlos, so.
Thank you, Your Honor. I had previously represented Mr. Self in the matter ending in 5140. Late yesterday, I was just appointed to.
Bond revoked. That means the defendant is headed back to jail. No, go home and think about it. Judges use this hammer when they feel someone isn't playing by the rules. Tough call, but sends a loud message.
his other matter, 5186. We are asking that both matters be adjourned in order for me to review discovery and work on a global resolution with the people.
Probable cause conference in these cases will be adjourned August 28th, 2025, 9 a.m. Bond continued.
Thank you, Judge. Defense may be heard as to bond.
Go ahead.
So, Your Honor, Mr. Self had previously received a bench warrant in the case ending in 5140. That's because he was in the hospital with extremely high blood pressure. He tried to leave. He tried to get his doctors to let him go, but the doctors said, well, you can stay here or you can go to court and have a stroke due to his extremely high blood pressure. So he opted to protect his health and stay. So unfortunately, he was predisposed. He did have his intake paperwork. I asked him to provide it for me, but unfortunately that was lost when your apartment flooded, was it?
Yeah.
So his apartment flooded and destroyed a lot of his belongings. So unfortunately, we don't have documentation for the court. He is also interested in.
Does that explain the cocaine use during July?
I don't believe that would be related, Judge, to that particular issue. But we have reached out to Sarah Stewart in the jail about getting into Dawn Farm in-jail treatment program. Mr. Self is a business owner. He owns a barbershop. He's eager to get back to work. He has 3 employees who rely on him for their livelihood, in addition to his own livelihood at the shop. The shop is currently closed and idled while he is in custody. So we are asking that he be released to be able to return to being a productive member of community and a job provider for the local community. And so we are asking for a PR bond on these matters.
I don't need a response from the people. His bond will continue as previous, as I've said it. In this case, motion for bond reduction is denied.
Understood. Thank you, Judge.
Denied. Prohibited the defense rolled out health issues, job loss, even flooding apartments to tug at the court's sympathy. But the judge isn't buying it. Bond decisions come down to one word: trust. And right now, trust is thin.
Your Honor, may we approach on this matter?
Is there really a need?
There's a lot of updates that I've been talking with Mr. Burgeons about, and
Is that to the use of recreational marijuana, which he's not supposed to do, or to the cocaine? Which is the update?
Well, it concerns both, Your Honor. It concerns all of the steps that he's taking, and specifically the documentation that he went to Home Division yesterday, and we are waiting documentation, and
Documentation for what?
that he did his intake at Home Division yesterday.
As well as CMH.
As well as CMH. And he came in with a written plan in his notebook. And I can honestly say I did not even tell him to do this, but he came in with a written plan about how he's going to stay clean.
If I test him today, is he going to test clean?
Yes, sir. But I won't in 2 days. Your Honor,
What?
Your Honor, I'm not lying to you. Judge Simpson, I've done everything that I could possibly do to make sure that I can continue to stay in society. I have a job. I start tomorrow at Full House Restaurant on Equals. I went to CMH and did my intake. I also went to Home Division and spoke with Mr. Marcus, who is a recovery coach on Equals. All these places are within a half a mile from each other, from the hotel living in now. So I'm in position to lose my room, my residence, as well as my relationship with my fiance, who's clean and clinging on by her fingernail, because I'm trying my best to do my best and change my lifestyle, sir.
What are we doing with this case?
So I do have a green sheet, Your Honor. This is a case that is from, I believe, 2022. It's a possession. And I would ask to adjourn it because I'm hoping it comes to some sort of resolution.
This is raw. You can hear the desperation, job on the line, relationship crumbling. Addiction cases aren't just about law. They're about survival. And judges have to decide, is this genuine change or just courtroom theater?
The bottom line is Mr. Burgins knows that he needs treatment. And I've had a lot of conversations with his fiance and him, and I really do think they are very active in making sure that he gets help, stays out of trouble. He just got this job. He has the sweatshirt that he's wearing. And he's eager to prove himself. And I think he's very genuine when he says, I mean, he asked me to ask this court to let him prove himself and to show with his actions that he is following up, that he's good to his word. I did call Home Divisions this morning and verified Mr. Marcus. I'm just waiting for his email response to come through, that he did actually go to the meeting yesterday. I did verify with his fiance, who is with him, that he did that, and that he is clearly not using. He came to court knowing that he had this bond violation, knowing what he risked in terms of his liberty, but he wanted to do the right thing, and he wanted to stand before this court to ask for the opportunity to show that he can be clean, he can be sober, he can be in the community, and he will do the right thing. He's very eager to prove himself. He has no other cases, not on probation or parole, and he has this new plan.
Recovery coach, new plan.
And he's going to Little House meetings multiple times per week.
I start work tomorrow, y'all. I just need an opportunity to prove to you that I can do the right thing. I know I've made some mistakes, some horrible decisions. I'm 62 years old. I'm old enough to know right from wrong. And I apologize for my shortcomings, but I'm trying to do the right thing. I can't prove it to you from there.
I have 4 positive tests. He's been using cocaine. It almost less than a week ago, I have a positive test regarding that.
I understand.
He doesn't have a valid medical marijuana card. He's also been using marijuana, or THC at least, in the system. You're telling me now, the day before he's to come to court, he's now in treatment.
I started
and somehow or another, I'm just supposed to say all of that's okay.
Well, Your Honor, he knows it's not okay. I think what makes him really different is he is coming, he is testing, and he is doing his best. It is obviously a struggle for him to battle his addiction, but he is not getting in trouble. He's going to meetings. He's doing the best that he can. And I think he's doing what, especially on his own initiative. I mean, I was surprised yesterday because he doesn't have his own cell phone. He shares with his fiance. And before I even talked with him, he came up with this plan himself. And I think that goes to show that he is taking the initiative to do this himself. And he is using this added accountability of testing. He knows that he's going to lose his liberty if he tests dirty one more time. I mean, he knows that. And he knew that coming into court today. And he still came in anyways because he wanted to prove to.
And there it is, bond revoked again, but with a lifeline. If he proves enrollment in treatment, the judge might reconsider. It's like a last chance card, but the clock is ticking.
The court that he is willing to take that chance. And he said, the court certainly will revoke my bond if I test positive again, but I'm not going to because I'm serious and I'm serious about recovery. And so I would ask this court for one more week, one more opportunity for Mr. Bergens to prove himself.
I can do it, Your Honor. I promise. I'll be locked up if I don't. I can't do anything from jail. I have a job now, and I want to prove to myself as well as the court.
Anyone can do from jail.
Sir?
Nothing.
I'm sorry.
I'll adjourn this out to the 28th, 2025 at 9 a.m. I don't need a response from the people. Defendant's bond is revoked. If you send me the proof that he's enrolled, I'll reconsider the revocation of his bond. But until such time, his bond's revoked. Defendant's remanded.
So what do you think? Was the judge too harsh or fair given the track record? Drop your thoughts in the comments because this case is the perfect mix of law, life, and second chances.